Hi, my name is Najun Menka. I'm Athabascan and Lumbee, and I'm a student here at Seattle University School of Law.
Hi, my name is Catherine O'Neill, and I'm a professor of law here at Seattle University School of Law.
So research involving or affecting American Indian, Alaska Native, and Native Hawaiian peoples is unique for a variety of reasons. Tribes' unique political, legal, and historical circumstances have numerous implications for those whose work impacts the health of tribal people, land, and resources.
Assumptions, conventions, and methods developed for the general population may be inappropriate where tribal people or tribal homelands are affected. Indeed, they may introduce bias, perpetuate inaccuracies, and lead to conclusions that are not scientifically defensible, culturally viable, or legally tenable.
We want to emphasize at the outset that, of course, each Native nation is different. So while we will discuss several common issues, it is always necessary to work directly with the individual tribe or tribes affected.
In this presentation, we will focus on three ways in which tribes are unique. Tribes are unique because they are sovereign entities engaged in political and cultural self-determination. Tribes are unique because they have certain legal rights to the lands and resources on which they've historically depended. And tribes are unique because of their particular historical circumstances within the United States. Experiences that have too often included violence, prosecution, intimidation, and discrimination. These experiences have shaped everything from tribal resistance to participating in scientific research conceived by outsiders, to tribal governance of tribes' natural, cultural, and intellectual resources today.
So researchers whose work potentially affects tribal resources or who might seek to collaborate with tribal partners need to understand these ways in which tribes are different from other identifiable groups within the general population and from other governmental entities within the United States.
We'll start by discussing the first of these three considerations. The tribes are unique because of their status as sovereign governments. We'll define the meaning of some central terms: nations, tribes, and peoples. And then we'll explore what tribal sovereignty means from both the perspective of tribes and the United States. We recognize that this presentation will just scratch the surface of a number of important and nuanced topics. We urge those interested to consult the primary and secondary sources from which we quote, and to explore the various materials and websites that we cite in the companion additional resources document that accompanies this video presentation.
So American Indian, Alaska Native, and Native Hawaiian peoples have existed for millennia. They existed as independent, self-governing peoples long before European colonizers set foot on this continent, long before the United States became a country. We use the term peoples in the sense that it is understood in international law, that is, as distinct political communities with unique legal status and rights, including rights to self-determination. This understanding is reflected in the United Nations Declaration on the Rights of Indigenous Peoples, which was adopted by the UN General Assembly on September 13, 2007, and was supported by the United States on December 16, 2010. We use the terms Native peoples, Native nations, and tribes interchangeably, and intend each of these terms to denote a status as sovereign governments.
Sovereignty essentially means self-rule, the collective right of a people to govern themselves and to pursue economic, social, and cultural development as they have defined it. In considering tribal sovereignty, these concepts can be illustrated by asking some basic questions. Who crafts the constitution that sets forth the structure of tribal government? Who sets and enforces the speed limit on the way into the tribal preschool? Who determines whether a tribal natural resource such as solar, wind, or hydropower gets developed, and under what conditions? Who issues hunting license, delineates the hunting season, and enforces bag limits? Who defines what or whom should be taxed and by how much? Who establishes the terms under which tribal, intellectual, and cultural data will be gathered, used, and owned? When the answer to these questions is the tribal government, tribes have sovereignty. To the extent that the answer to these questions is some non-tribal government, tribal sovereignty is compromised. Sovereignty is an inherent attribute of nationhood. It's not conferred or granted by other entities, including other nation states. However, a nation's sovereign status may be acknowledged or affirmed by other statements and acts.
So while the terms nation or tribe may themselves have been introduced, the concepts of sovereignty and self-determination have deep roots among Native peoples here. Consider, for example, the understandings of sovereignty expressed in these statements by various Native leaders. Wilma Mankiller of the Cherokee Nation states that, "I think that the sovereign rights of tribes are inherent, and I think that when thinking about that sovereign, it's important to remind everyday Americans that tribal governments existed before there was a United States government, and that many tribes, including the Cherokee Nation, had treaties with other governments before they had a treaty with the first United States colony. So the definition of sovereignty is to have control over your own lands and resources and assets, and to have control over your own vision for the future, and absolutely determine your own destiny." Brian Cledesby of the Swinomish Indian tribal community stated that if you give Indians the resources, time, and opportunities to solve any problems we face, there is nothing we can't do. That is sovereignty. We need our non-Indian friends and institutions, but the best solutions to problems in Indian country always come from Indian country. That's sovereignty. We've been solving problems in Indian country for thousands of years. That's sovereignty. We'll keep solving them if our friends live up to their promises and let us take care of our own future. Frank Garowagishik, Little Traverse Bay Bands of Odawa, states that we, the Little Traverse Bay Bands of Odawa Indians, speak through this document to assert that we are a distinct nation of Anishinaabe of North America that possess the right to self-determination, freely determine our political status, freely pursue our economic, social, religious, and cultural development, and determine our membership without external interference. These are the same rights and principles that the Little Traverse Bay Bands of Odawa Indians acknowledge to be inherent among other peoples, nations, and governments throughout the world. We recognize their sovereignty and pledge to maintain relations with those peoples, nations, and governments who acknowledge those same fundamental rights and principles, and who recognize the sovereignty of the Little Traverse Bay Bands of Odawa Indians." Having considered some tribal perspectives on Native nation sovereignty today, we now turn to the perspective of the United States.
While the concept of self-rule is straightforward, tribal self-rule has not been recognized and supported in its fullest sense on this continent. Rather, tribal sovereignty is understood by the United States to have particular contours. This understanding, moreover, is complex and evolving. Native nations' distinct sovereign status is evidenced in part by the fact that the United States entered into treaties with them. For example, the United States Supreme Court, in one of its earliest cases, stated, "The very term nation, so generally applied to Indian tribes, means a people who are distinct from others. The Constitution admits their rank among those powers who are capable of making treaties." Joseph Kalt and Joseph Singer, scholars of tribal governance and Indian law, put it this way: "The very act of treating is a nation-to-nation form of intergovernmental interaction." Kalt and Singer go on to explain, "Most, but not all, tribes entered into treaties with the United States. The resulting treaties did not and do not absorb the tribes into the United States. Rather, the reverse is true. The treaties recognize and preserve tribal sovereignty. In return for giving up almost all the land in the U.S., the U.S. made promises to the tribes. It promised to respect their rights over reserved land and to recognize that those lands would be governed by tribes, not by state governments." Indian law scholar Rob Williams observes that treaties were often created to form alliances between Native and European nations, or at least to set the terms for coexistence of Native and European peoples on this continent. As Williams observes, the European invasion of North America in the 17th and 18th centuries left the continent's indigenous tribal peoples with little choice but to meet head-on the numerous challenges of creating and sustaining cooperative relationships and firm alliances with the newcomers to their lands. To prevent European encroachment on their territories and independence, tribes throughout eastern North America strengthened and renewed ancient political institutions, reinvigorated old alliances and tribal confederacies, and in many instances sought to, quote, link arms together with European newcomers through treaties negotiated according to indigenous North American visions of law and peace in a multicultural world. Tribes' status as sovereigns within the federal system is also recognized by the U.S. Constitution. Indian law scholar Matthew Fletcher explains, "The Constitution delineates the authorities, duties, and limitations of the United States in relation to the state governments, but the structure and text of the Constitution recognizes two other kinds of sovereign entity, foreign nations and tribal nations. As Justice O'Connor once stated, Indian tribes are the third sovereign."
From the United States perspective, however, tribes' sovereign status has unique contours. These contours have been determined over the years not only by treaties and the Constitution, but also by acts of Congress and Supreme Court case law. Fletcher observes that three general fundamental principles of federal Indian law can be derived from these sources. First, Congress's authority over Indian affairs is plenary and exclusive. As concomitant principle, the federal government holds obligations to Indian tribes and individual Indians known as the trust responsibility. Second, state governments have no authority to regulate Indian affairs absent express congressional delegation or granted in accordance with federal government's trust obligations. Third, the sovereign authority of Indian tribes is inherent and was not delegated or granted by the United States, but can be limited or restricted by Congress in accordance with its trust responsibility. Congress must clearly establish and express its intent to abrogate an aspect of tribal sovereignty. Each of these three principles warrants discussion in far more detail than we have time for here. Nonetheless, with even this summary, we can begin to appreciate the United States' understanding of tribal nation sovereignty, and it's different from its understanding of foreign nation sovereignty. We can see that, from the perspective of the United States, the sovereign status of the Lummi Nation, or the Hopi tribe, or the Forest County Potawatomi community are different from the sovereign status of France, for example. While the United States, on one hand, clearly recognizes tribes within its boundaries as a third sovereign within the federal system, the U.S., on the other hand, clearly asserts limitations on tribal self-rule. Most notably, as Fletcher puts it, Congress asserts, and the Supreme Court recognizes, a plenary power over Indian affairs. The specter of this sweeping, potentially absolute congressional power remains as a qualification on more robust claims of tribal sovereignty.
Additionally, it's important to note that the United States' understanding of its relationship to tribal nations has fluctuated dramatically over American history. The U.S. has officially embraced policies as divergent as encouraging native-to-native treaty making, to terminating tribes as governmental entities, to forcing the assimilation of Native people into mainstream non-Native society, to finally, in the present era, affirming tribal sovereignty and supporting tribal self-determination. The divergent and often conflicting goals of these historical eras have left a legacy that continues to present extraordinary challenges to tribal governance today. Yet, every U.S. presidential administration since the 1960s has denounced former efforts to terminate tribal governments and assimilate tribal people, and has instead called for enhancing tribal sovereignty and supporting tribal self-determination. For more than 5 decades then, the United States' official Indian policy has been described as the self-determination era.
During this current era, there have been numerous examples of efforts within Congress and the executive branch to honor the federal government's commitment to tribal self-determination and to support tribes' efforts to enhance tribal governance, develop tribal economies, and improve the health and prospects for tribal members. However, while official federal policy continues to affirm tribal sovereignty, the judicial branch, in particular, has recently moved in the opposite direction. As Kalt and Singer observe, over the last decade in particular, the Supreme Court has moved repeatedly to limit tribal powers over non-members. Lower courts have fed this process with decisions that increasingly rein in the ability of tribal governments to govern commerce and social affairs on the reservations. When tribes exercise their sovereignty or jurisdiction, it is still frequently the case that their authority or to do so is challenged in court. If the Supreme Court remains hostile to tribes' claims, tribes' abilities to govern, to exercise their sovereignty in practice, it is threatened.
So, tribes today continue to exist as distinct sovereigns within the boundaries of the United States. They're governments with obligations to ensure the health and well-being of their citizens. The preamble to the Constitution of the Quinault Indian Nation, for example, emphasizes the tribe's responsibility to preserve its land base, culture, and identity. Tribes are in this respect not unlike their state and U.S. governmental counterparts, alongside whom they act in our tripartite system. Although the contours of the relationship between these three sovereigns have shifted over the years and remain complex, tribes are recognized as having a unique political and legal status. This status sets tribes apart from every other community or group that might be affected by decisions about natural, cultural, or intellectual resources. And this status differentiates tribes from other identifiable groups within the general U.S. population and from other governmental entities with whom researchers might seek to collaborate. Now we turn to the second way in which tribes are unique.
So tribes have various rights to use the lands and resources on which they have historically depended. These rights have been recognized in countless treaties, agreements, and executive orders, and have been affirmed in numerous court decisions. Here, again, it is important to note that each tribal nation is different, and that various tribal rights have been recognized by a range of legal mechanisms. The legal bases regarding or recognizing Alaska Native rights, for example, differ from those affirming Native Hawaiian rights, and so on, and will always be necessary to research and understand the applicable laws to a particular tribal nation. Still, it is possible to highlight some generalities across tribes. According to the legal treatise, Felix Cohen's Handbook of Federal Indian Law, tribes generally retain exclusive rights to the use of land and resources within their territories, unless those rights have been abrogated by treaty or statute. Many tribes also have non-exclusive rights on the use of land and natural resources outside their territories or reservations. Many tribes reserved hunting, fishing, and gathering rights on land ceded to the federal government by treaty or by agreement subsequently ratified by statute. These rights to access, harvest, and use natural resources are rights that are inherent in specific tribes. Fishing rights, for example, belong to a particular tribe, for example, the Nez Perce tribe or the Penobscot Nation, and not to Indians more generally as a racial ethnic group. While these rights can be exercised by individual Nez Perce or Penobscot tribal members, the rights are not individual rights, but a tribal right. That is, the right is a sort of a property right that belongs to the tribe itself. Federal support for tribal management of natural resources, like federal support for tribal governmental authority, is complex and evolving. As is the case more generally, the three branches of the federal government have taken a variety of actions that have sometimes enhanced and sometimes undermined tribal use and management of the lands and resources to which they have rights. In the discussion that follows, we will examine one example, that of a treaty-secured fishing rights held by tribes of the Pacific Northwest. This example is useful in part because it pertains to off-reservation rights that have been reserved by the tribes, a category of tribes' unique rights that is often misunderstood, and in part because it illustrates federal courts' role in recognizing the scope and reach of tribal rights to use and manage natural resources.
Tribes in the Pacific Northwest are fishing peoples. Fish and all of the life ways that go with the fish are essential to tribal health and well-being, today as in the past. Every facet of managing, harvesting, distributing, and honoring the fish are woven into the fabric of tribal life. For the fishing tribes, these lifeways predate European contact. Tribes' rights to fish are thus aboriginal in origin. When the tribes ceded vast expanses of their homelands to the United States by treaty, they reserved the right to continue to fish, hunt, and gather, and secured a promise from the United States that this right would be protected in perpetuity. For example, the Treaty of Point Elliott provides that the right of taking fish at usual and accustomed grounds and stations is further secured to said Indians in common with all citizens of the territory. However, it didn't take long before the tribe's treaty-secured fishing rights were challenged, as European settlers sought to bar tribal access to their traditional fishing places, to prohibit tribal members from fishing by violence or threats, to use fishing devices and methods that took the bulk of the fish for themselves. So tribes soon found themselves in court having to defend their rights. And the tribes have had to continue this effort into the present day. Over the years, U.S. courts have affirmed several important aspects of tribes' fishing rights. Early on, the courts emphasized that all of the rights not expressly relinquished by the tribes were retained. This remains a crucial tenet of federal Indian law. According to the U.S. Supreme Court, treaties represent, quote, not a grant of rights to the Indians, but a grant of rights from them, and a reservation of those not granted. U.S. courts have also held that the rights to take fish necessarily includes a right of access by tribal fishers. As explained in Cohen's Handbook of Federal Indian Law, off-reservation hunting, fishing, and gathering rights are servitudes over the burdened lands. Neither states nor private property owners may bar tribal access to lands subject to treaty hunting, fishing, and gathering rights. In the 1970s, in an important case titled U.S. v. Washington, but often referred to as the Bolt decision after the federal district court judge who decided the case, the court found that the treaty clauses regarding off-reservation fishing secured to the Indians rights, privileges, and immunities distinct from those of other citizens. Other facets of the right to take fish have also been adjudicated by U.S. courts over the years, including, importantly, tribal government status as co-managers, along with the state of Washington, of the off-reservation fishery resource. More recently, in a sub-proceeding of U.S. v. Washington, the courts have been called upon to address a threat to tribes' fishing rights posed by environmental degradation. In what's colloquially known as the Culverts Case, filed in 2001, the tribe cited evidence that the state of Washington had improperly maintained culverts around the state, with the result that miles and miles of salmon habitat were blocked. This contributed to a decline in salmon numbers, and thus an erosion of tribes' ability actually to exercise their treaty-protected right to take fish. In 2007, the federal district court sided with the tribes. Judge Martinez quoted the Supreme Court's earlier work in the U.S. v. Washington line of cases, which had recorded the treaty parties' likely understandings at the time that the treaties were negotiated in the 1850s. Quote, during the negotiations, the vital importance of the fish to the Indians was repeatedly emphasized by both sides, and Governor Stevens' promises that the treaties would protect that source of food and commerce were crucial to obtaining the Indians' assent. Judge Martinez next spoke to the parties' likely understandings regarding the prospect of environmental degradation. He observed it was not deemed necessary to write any protection for the resource into the treaty because nothing in any of the parties' experience gave them reason to believe that would be necessary. He then quoted historian Joseph Taylor. During 1854 and 55, white settlement had not yet damaged Puget Sound fisheries. During those years, Indians continued to harvest fish for subsistence and trade as they had in the past. Given the slow pace of white settlement and its limited and localized environmental impact, Indians had no reason to believe, during the period of treaty negotiations, that white settlers would interfere, either directly through their own harvest or indirectly through their environmental impacts, with Indian fisheries in the future. During treaty negotiations, Indians, like whites, assumed their cherished fisheries would remain robust forever. So, Judge Martinez concluded, the representatives of the tribes were personally assured during the negotiations that they could safely give up vast quantities of land and yet be certain that their rights to take fish were secure. These assurances would only be meaningful if they carried the implied promise that neither the negotiators nor their successors would take actions that would significantly degrade the resource. The significance of the Culverts Order was immediately recognized, and although the state of Washington and the tribal parties attempted to settle upon a schedule for the state to fix their stream-blocking culverts, they were unsuccessful, so went back to court in 2010. In March of 2013, Judge Martinez again sided with the tribes. Judge Martinez decided this case in view of the discrete set of facts before him. He carefully avoided a broad, acontextual pronouncement about the scope of treaty protections for fish habitat. Yet, the Culverts decision can fairly be read to confirm the point that as successors to the negotiators, federal and state governments may be held to account for the actions that they take or that they permit others to take that significantly compromise the treaty fish resource. In view of the potential import of this decision, it's perhaps unsurprising that the state of Washington filed an appeal to the Ninth Circuit in May of 2013. The Ninth Circuit has heard oral argument in this appeal, but as of May 2016, has yet to issue a decision. We wish to emphasize that this is but one example and that the analysis that we've summarized here applies specifically to this example, that is, that of treaty-secured fishing rights. But this example highlights the fact that tribes have legal rights to lands and resources that are distinct from fishing privileges enjoyed by non-tribal citizens. It highlights the fact that tribal governments have co-management authority for the fish resource, a sovereign authority that extends beyond their reservation boundaries. It highlights the reserved nature of tribes' fishing right, that it's not a special right bestowed by the U.S. government, but an aboriginal right retained by the tribes. And it highlights the role of U.S. courts in delineating the scope of the right in practice, for good or for ill. All of these points would need to be understood by a researcher whose work implicated tribal harvest or use or management of the fish resource. We turn now to a third way in which tribes are unique, a way that also needs to be appreciated by researchers seeking to collaborate with tribes. Tribes and tribal people have particular historical experiences in the United States that are not shared with other individuals or groups within the general population.
So throughout American history, even into the modern era when the United States had formally recognized tribal sovereignty and officially embraced self-determination, tribes and tribal people had experienced violence, persecution, intimidation, discrimination, and other harms when they have sought to exercise their rights to use and manage their natural, intellectual, and cultural resources. These decades, in fact, have contained many grim chapters, during which the United States government sought literally or figuratively to, quote-unquote, kill the Indian, to destroy tribal languages and cultures, to impose Christian religions and dismantle tribal ownership of their homelands, and to thwart Native people's ability to fish, hunt, gather, and otherwise manage their resources. These years also witnessed physical and ethical abuses by government and university-sponsored scientists. Tribal people were deeply traumatized by these experiences. They still remember them and talk about them. Tribal people carry the scars of these today, and these scars, understandably, affect their responses to outside researchers hoping to collaborate with tribes. In fact, many non-tribal researchers have not been sufficiently made aware of these historical circumstances, generally and with respect to particular tribes, and thus have not appreciated the ongoing legacy of these traumatic experiences. As a result, they have been too often led to misinterpreted data or misframed research questions, prioritized projects that were of little benefit to the tribe that was the subject of their study, exploited intellectual, cultural, and biological data and materials for unauthorized purposes, or employed conventions, assumptions, and methods that were not appropriate. While tribal governments may seek to encourage research that will be of benefit to the tribe, at the same time, they may be wary of government and university-supported scientists.
Consider, for example, the need to appreciate the history and legacy of the fishing wars if one is seeking to understand fish consumption practices among tribal people in the Pacific Northwest, or to interpret data afforded by conventional fish intake surveys, which take a snapshot of contemporary fish consumption rates. As Barbara Harper and Jamie Donatuta point out, the conventional approach is not culturally appropriate for the fishing tribes, and thus leads to results that are simply not accurate. They identify 6 common methodological flaws when conventional approaches are simply applied to assess tribal fish intake. They also emphasize the fundamental error that's made when researchers focus on contemporary practices, given that tribal people's contemporary fish intake is suppressed relative to historical, or what they term heritage, practices. That is, tribes are able to harvest and consume less fish today due to depletion and contamination of the fish resource, lack of access to fishing places, shellfish harvesting closures, and years of prosecution, intimidation, and gear confiscation. The resulting fish consumption rate derived by conventional research methods will therefore be biased downward. Importantly, given that these tribes have treaty-secured rights to harvest and consume fish, an appropriate research question from the perspective of the tribes might not be to ascertain contemporary suppressed practices, but might instead be to ascertain heritage rates consonant with the robust fish intake that's guaranteed by the treaties. This would be a matter for each tribe to determine for itself, of course, but recent surveys of tribal fish consumption practices undertaken by the Lummi Nation and by the Nez Perce tribe have pursued such alternatively framed research questions. To understand Harper's and Donatuto's observations about the flaws in conventional methods and assumptions, researchers need to appreciate the legacy of tribes' experiences during the 1960s and 1970s. Some fishing families had their gear confiscated during these years, and deprived of their means of livelihood, they were never able to scrape together the money to buy new boats and gear. Families that had for generations always had fish to eat today are forced to look elsewhere for work and food, and are often forced to participate in the cash economy or to rely heavily on government commodity foods.
They started going to jail. There were fights along the river. I mean, these guys were out to hurt you. They weren't just doing simple things. They wanted to hurt you, and they wanted to hurt you bad. They'd carry these long flashlights, and it was like they were terrorizing the Indians. But that's what's so angry is when these guys went to jail, we sat home and we starved as families, but you know, it didn't matter to them. And then when we got done, we didn't have anything. They took our boats, they took our nets. Did they take the fish too?
Yeah, they took everything.
They just took everything from you. And
our guys got shot at, and they got beat up, they got equipment stolen, tore up. Just so much happened on there, but we're still in there fighting.
If a researcher uses a conventional approach and takes a snapshot of fish consumption today, this may fail to plumb the reasons behind current suppressed fish consumption rates.
So to take a second example, consider the need to appreciate the history and legacy of the Havasupai Tribe's experience with university researchers. The Havasupai Tribe Reservation is located near what is now the southwest corner of the Grand Canyon National Park. In the 1960s, the Havasupai developed a working relationship with an Arizona State University anthropologist, Mr. John Martin. Because the tribe trusted Martin, they approached him several years later in 1989 to ask for assistance in determining why the incidence of diabetes had drastically increased within the tribe. Martin, in turn, approached a geneticist at Arizona State, Teresa Markow, to assist in determining if genetic factors were increasing the tribe's risk, which had recently been found to be the case with the Pima Indians. From 1990 to 1994, blood samples were taken from over 100 Havasupai tribal members who had signed a broad consent form authorizing the use of the samples for medical studies. Eventually, it was determined that genetics did not play a role in increasing the tribe's diabetes levels. However, unbeknownst to the tribe, the blood samples continued to be used by researchers for other studies, purporting to inquire into schizophrenia, metabolic disorders, and alcoholism in the tribe's population. Later, an ASU graduate student used the blood samples that were still stored in the university's freezers to conduct research for his dissertation. The unauthorized uses of tribal DNA did not come to light until a tribal member present at the doctoral student's dissertation presentation asked if the student had permission to use Havasupai blood for his research. This pointed question revealed that free, prior, and informed consent was lacking in the Havasupai case. As Kim Tallbear has observed, the affront was not only to the individuals whose blood and therefore DNA was misused, but also to the tribe as a whole. Tribal self-determination is threatened when researchers, funders, government agencies, and non-governmental organizations decide what constitutes legitimate and ethical research in Indian country. Additionally, several months later, an ASU investigation discovered 24 published articles based on the blood samples that the ASU researchers had collected. One of the papers posited that the Havasupai tribe had migrated across the Bering Strait, a suggestion that directly contradicts the tribe's traditional stories, which identify their origins in the Grand Canyon. Tallbear takes issue with researchers who study American Indians and become the experts that represent us to the world. She observes that scientists' statements about the origins of Native Americans are debatable from both genetic and anthropological points of view, and argues that a more important problem is that such statements are authoritative claims to power. The power to define and represent American Indian peoples, to determine, according to particular biological and anthropological criteria, i.e. not Native American or American Indian criteria, which aspects of our bodies, histories, and kinship relations count as true and real in understanding American Indian identity. In the Havasupai case, the researchers substituted their ways of knowing for the tribe's ways of knowing, presenting their perspective as an objective scientific truth. There are numerous potential issues when researchers attempt to speak for a tribe. For example, the National Congress of American Indian notes, if a migration study suggests that a tribe originally came across the Bering Strait from Asia, the results of the study might have political implications and be used to challenge tribal sovereignty and land rights in the future. The Havasupai case illustrates a host of troubling issues. It is important to understand and learn from the history of this and other research efforts in tribal communities. These historical experiences, among other things, may continue to color tribes' responses to outside researchers as a result.
As Stuart Harris has argued, the time has come for a new model in which tribes' governmental status is respected. Tribes' unique concerns for control over their natural, intellectual, and cultural resources and data are addressed, and crucially, tribes and tribal members are viewed as collaborators in, and not merely subjects of, scientific research. This new model, notably, is consonant with the various rights recognized by the UN Declaration on the Rights of Indigenous Peoples, including those rights contained in Articles 31 and 32. In closing, we offer a few observations on this new model. As the National Congress of American Indians has stated, increasingly, tribal leaders acknowledge that research is a key tool of tribal sovereignty in providing data and information to guide community planning, cross-community coordination, and program and policy development. Tribes have used research as a tool of sovereignty to address issues like water quality, early childhood education, cancer, diabetes, and elder care. However, while Native people are one of the most studied groups in the United States, there is, paradoxically, a dearth of quality data and research that is reliable and relevant to tribal governance, to tribes' efforts themselves to shape policy and develop solutions to the social problems they face. Tribes today are seeking to address that dearth.
To this end, NCAI offers a set of core values for consideration in framing respectful research partnerships involving or affecting tribes. 1, to acknowledge that Indigenous knowledge is valid and valued. 2, culture is always a part of research, and thus research cannot be culturally neutral. 3, responsible stewardship includes a task of learning how to interpret and understand data and understand data and research. 4, tribes must exercise sovereignty when conducting research and managing data. And 5, research must benefit Native people.
Further, NCAI emphasizes that it's crucial for researchers entering into sustainable partnerships with Native communities to develop an understanding and respect for, number 1, Indigenous cultures and knowledge, number 2, tribal sovereignty, and 3, tribes' historical experiences and present-day context. As Kim Tallbear urges, perhaps the most vital step toward ensuring observance of these core values and respect for tribes' culture, sovereignty, and historical experiences is expansive tribal governance of research. That is, tribes can issue laws, regulations, and policies to manage natural, intellectual, and cultural resources use, to govern use, custody, and ownership of tribal data, to craft and enforce tribal ethical protocols, and to otherwise set the terms under which research affecting tribal lands, resources, peoples, and cultures is conducted.
Several tribal nations have undertaken such governance efforts. These can serve as models for other tribal nations and should be respected by outside researchers.